friends, welcome to iExamB's Law channel LegalB. Last week I announced about an upcoming series of 300 most important law questions from various subjects, and today we are going to discuss the first part of that series. I have already given you a test of first 20 questions from the Companies Act. In this video we are going to discuss solutions to that questions. I have already given you a schedule of these 300 important law questions. I will rediscuss the schedule at the end of the video so that you can come prepared next Friday for the next coming test. The first question in today's series was, a private company can raise funds through which of the following? The correct answer is both A and C. A private company cannot raise funds through the issue of prospectus, because a private company cannot issue shares to the public. A private company, however, can raise funds through right issue and private placement. This is given under section number 23, which talks about public offer and private placement. In this, it is clearly mentioned a private company may issue securities by way of right issue or bonus issue in accordance with the provisions of this act, or through private placement by complying with the provisions of part 2 of this chapter. Second question is, the correct statement relating to a shelf prospectus are. The correct answer here is D, both A and B. Option C is not correct. Validity period cannot exceed more than 2 years or as may be prescribed. This is given under section number 31, which talks about shelf prospectus. Here the validity period is clearly mentioned as not to be exceeding 1 year. Now moving to the third question, a company limited by shares may, if so authorized by its articles, issue preference shares which are liable to be redeemed within a period of. The preference shares should be redeemed within a period not exceeding 20 years from the date of their issue, except when we are talking about infrastructure projects. This is given under section number 55, which talks about issue and redemption of preference shares. A company limited by shares may, if so authorized by its articles, issue preference shares which are liable to be redeemed within a period not exceeding 20 years from the date of their issue, subject to such conditions as may be prescribed, provided that a company may issue preference shares for a period exceeding 20 years for infrastructure projects. Also, the maximum time limit of infrastructure projects is given under Companies Share Capital and Debenture Rules 2014, in which it is given that it should not exceed 30 years at one point of time. Moving to the fourth question, as per the Companies Act, the securities premium account cannot be used for. The correct answer is payment of dividend. This is given under section number 52, which talks about application of premiums received on issue of shares. The security premium account may be applied by the company towards the issue of unissued shares of the company to the members of the company as fully paid bonus shares, in writing of the preliminary expenses of the company, in writing of the expenses or commission paid or discount allowed on the issue of shares or debentures of the company, in providing the premium payable on the redemption of any redeemable preference shares, or for the purchase of its own shares or other securities. It cannot be used for the payment of dividend. Moving to fifth question, all shares in respect of which dividend has not been paid or claimed for 7 consecutive years or more shall be transferred by the company. The correct answer is to Investor Education and Protection Fund. So if there is unclaimed dividend amount for 7 consecutive years, it will be transferred to Investor Education and Protection Fund. This is given under section number 124, which talks about unpaid dividend account. Question 6 is, what is abridged prospectus? The correct answer is both A and C. Abridged prospectus is a summary of prospectus and it is a memorandum containing salient features of the prospectus. However, it does not enable an issuer to make a series of issue. This abridged prospectus definition is given under section number 2, subsection 1, where it says abridged prospectus is a memorandum containing such salient features of the prospectus as may be specified by SEBI by making regulations in this behalf. Question number 7 is, what is the minimum and maximum number of select group of persons who can be identified by the board for offer of securities or invitation to subscribe securities under private placement? The correct answer is minimum can be 50 and maximum can be 200. This is given under section number 42, which talks about offer or invitation for subscription of securities on private placement, and it is clearly mentioned it shall not exceed 50 or such higher number. This higher number is specified in the rules in Companies Prospectus and Allotment of Securities Rules 2014, where it says an offer or invitation to subscribe securities under private placement shall not be made to persons more than 200 in the aggregate in a financial year. Question number 8 is, the special resolution authorizing the issue of sweat equity shares shall be valid for making the allotment within a period of dash months from the date of passing of special resolution. The correct answer is not more than 12 months. This is given under section number 54, which talks about issue of sweat equity shares. Here clause D says, where the equity shares of a company are listed on a recognized stock exchange, the sweat equity shares are issued in accordance with the regulations made by SEBI. Then in Companies Share Capital and Debenture Rules 2014, Rule A talks about issue of sweat equity shares, and it says the special resolution authorizing the issue of sweat equity shares shall be valid for making the allotment within a period of not more than 12 months from the date of passing of special resolution. Question number 9 is, what is the time period within which the first meeting of board of directors of a company should be held from the date of its incorporation? The correct answer is 30 days. Within 30 days, the first meeting should be held. This is given under section number 173. Question number 10 is, the quorum for a meeting of the board of directors of a company shall be dash, and the participation of directors by video conferencing or by other audiovisual means shall also be counted for the purpose of quorum. The correct answer is 1/3 of its total strength or 2 directors, whichever is higher. Therefore, the quorum is 1/3 or 2 directors, whichever is higher. This is given under section number 174, which talks about quorum for meetings of board. The quorum for a meeting of board of directors of a company shall be 1/3 of its total strength or 2 directors, whichever is higher. Moving to next question, what is related party transaction? Related party transaction means dash. The correct answer is all of the above. Section 188 talks about related party transactions, and here it is mentioned, except with the consent of the board of directors given by a resolution at a meeting of the board and subject to such conditions as may be prescribed, no company shall enter into any contract or arrangement with a related party with respect to. So what all is included in related party transactions? Sale, purchase or supply of any goods or materials with any related party, selling or otherwise disposing of or buying property of any kind, leasing of property of any kind, availing or rendering of any services, appointment of any agent for purchase or sale of goods, materials, services or property, such related parties' appointment to any office or place of profit in the company, its subsidiary company or associate company, and underwriting the subscription of any securities or derivatives of the company. So all these transactions with any related party become related party transactions. Moving to next question, the article of a company may be altered by. The correct answer is a special resolution. A special resolution is required in order to alter the articles of a company. Section 14 of the Companies Act deal with alteration of articles. Subject to the provisions of this act and the conditions contained in its memorandum, a company may by special resolution alter its articles, including alterations having the effect of conversion of private company into a public company or a public company into a private company. A special resolution is required for such alteration. Moving to next question, the first annual general meeting of the company shall be held. The correct answer is within 9 months from the date of closing of the first financial year of the company. This is given under section 96, which talks about annual general meeting of a company. It says that not more than 15 months shall elapse between the date of one annual general meeting and that of next. Also provided that in the case of first annual general meeting, it shall be within a period of 9 months from the date of closing of the first financial year of the company and within a period of 6 months from the date of closing of financial year in any other case. The first annual general meeting should be within a period of 9 months and the rest can be within a period of 6 months. Moving to next question, that is question 14. What is the requisite quorum for the meeting of private company? So we have already discussed the quorum for a public company. Now we are moving to quorum by a private company. The correct answer is 2 members personally present. Section 103 deals with the quorum of meetings and it says unless the articles of a company provide for a larger number. In case of a private company, 2 members personally present shall be the quorum for a meeting of the company. The next is question number 15. A small company is a company whose paid up capital and turnover shall not exceeding rupees 4 crores. The paid up capital should not exceed 4 crores and turnover shall not exceed 40 crores. This is mentioned under Company Specification of Definition Detail Rules 2014, in which there has been an amendment made recently, and the paid up capital and the turnover of the small company shall not exceed 4 crores and rupees 40 crores respectively. Question number 16 is the maximum number of directors in a public company can be dash, and it can be more than the said number if the company passes a. The maximum number of directors in a public company can be 15 and they can be increased by passing a special resolution. This is given under section number 149, which talks about company to have the board of directors, and how many board of directors are required, that is also mentioned here. It says there shall be a minimum of 3 directors in case of public company and 2 directors in case of private company, 1 director in case of 1-person company, and a maximum of 15 directors, provided this may increase the number of 15 after passing a special resolution. Question number 17 is how many schedules are there under Companies Act? The correct answer is 7. There are 7 schedules. Schedule 1 deals with memorandum and articles. Schedule 2 deals with depreciation. 3 deals with balance sheet and statement of profit and loss. Schedule 4 talks about code for independent directors. 5 for appointment of managing director, whole-time director and manager. Schedule 6 deals with infrastructure projects, and 7 deals with corporate social responsibility. Question number 18 is a prospectus shall not be a valid prospectus if it has been issued. Correct answer is C. More than 90 days after the date on which a copy is delivered to the registrar for filing. If a prospectus is issued after 90 days of a copy being delivered to the registrar for filing, then it is not valid. This is given under section number 26, which talks about matters to be stated in prospectus. Here subsection 8 deals with the validity of that prospectus. Moving to question number 19. What is the minimum number of members required to form a public company? Very easy question. The correct answer is minimum 7 members are required to form a public company. Section 3 talks about the formation of the company. Here the number of members are given for public, private and 1-person company. For a public company, 7 or more persons are required. For private company, 2 or more persons are required. And for 1-person company, there can be 1 person. Moving to the last question of today's video, of today's test. Which of the following is true related to red herring prospectus? The correct answer is all A, B, C. It is issued prior to the issue of prospectus. It shall carry the same obligations as are applicable to a prospectus. It shall be filed with the registrar at least 3 days prior to the opening of subscription list and be offered. This is defined under section number 32, which talks about red herring prospectus. Red herring prospectus is issued prior to the issue of prospectus. It is kind of similar to the prospectus. It lacks 2 important details. One is the price of the shares being offered, and the second is number of shares being offered. Now today we have discussed the first part of this series, questions on Companies Act. On 30th of September, next Friday, we will be discussing important questions from IPC, Indian Penal Code. Along with this, we are posting questions regularly on our YouTube community at LegalB YouTube channel. You can attempt those questions on a daily basis to have a random practice of various acts and laws. Subscribe to our LegalB YouTube channel. This is your one-stop solution for all legal exams. If you have any doubts, you can write your queries in the comment below. You can also call us on this number mentioned on the screen. iExamB helps you unfold your potential and achieve your dream job. Stay tuned with this series. Be prepared for the next set of questions. Thank you.